Okay, I think we're on the record. I was just gonna go over what we're gonna do this morning. We have tentatively agreed to 10 different articles that you have proposed.
Did we re-sign that discrimination one?
We didn't re-sign it. We've signed it. We've already signed it previously. I even have a.
Okay. But that's one of the 10 that you're counting. I'm just
no.
making... Oh no.
The 10 that I'm counting were from yesterday.
Can we go over those?
Yeah,
real
and
quick?
I was going to go over them really quickly just to make sure we're both on the same page. So there will be 11, including the non-discrimination.
Okay.
The one, I'll start with the first. Let me see if I can find it. Where is it?
I've got number 1, preamble.
Hold on, let me
Okay.
find the emails. Okay, you sent the TAs in 2 separate emails. The non-discrimination provision has already been TA, so I'm not including, that's separate, so that's 1. The ones that I have passed over are TA1 preamble, TA3 recognition,
Okay.
TA7 employee rights,
Okay.
TA22 hiring and probation,
Okay.
TA26 severability,
Yeah.
TA29 no strike, no lockout, TA31 drug testing, T34 promotional bypass, T37 concluding provision,
Yeah.
and from the second email, we are TAing TA36, the preemption of civil service.
Oh, okay.
Okay.
That's the one I didn't have.
Yeah, and that's the one you had proposed new language, and we had discussed it at the table.
Okay.
We reviewed it, and it seems to serve the purpose, and the intent is clear on that. Basically, as we're authorized by Chapter 174, we're able to collectively bargain and modify certain civil service requirements. As modified by the collective bargaining agreement, those will actually modify those. Whatever is not modified, unless otherwise stated, I don't think there's anything in our collective bargaining agreement so far that would totally trump any civil service, an entire section.
Right.
But whatever's not trumped, unless it says so in the contract, the Civil Service Act still
Yeah, that's
holds.
right. That's right.
So we agreed to that. It was
Okay. Very good.
it seemed clear. So far we should have 11 tentative agreements, of which there's a lot of subsections covered within those 11 tentative agreements.
Yeah. Sure. Let's talk about that. I'm not sure what you're asking. Let's talk about that the next part. We'll clear it up. Yeah, sure.
Yeah. I wrote it, Johnny. Trust me. I wouldn't let you down.
It's just a question.
And I just wanted to note also, as we've discussed, and just for the record, that we're agreeing to the substantive portions. The articles that we're using are to make it, they're under your articles, what you have proposed, and it's to make it easy and identifiable during the course of these negotiations. But at the end, we'll have to reorganize or organize the complete agreement in a logical, easy to read way.
That's right. Especially towards the end of it, I've just added things on as they've come up.
Sure.
And so, yeah, we can.
It just makes it easily
definitely
identifiable, and that's why we're doing it.
And we
that
can
way.
definitely reorder it.
Okay.
I'm not looking at
With respect to the additional proposed tentative agreements you sent us in that second email, which I'll identify as TA14, TA21, and TA30.
I also had I had asked you to look at 20, which is injury leave, and you asked me a couple of questions about it yesterday, about whether or not it changed the existing contract requirements. So, yeah, I'm assuming that y'all will either tell us we can TA on it, or we have a problem with this or that language and here's a counter.
Yeah, I think what we're probably gonna be working on that, is, I believe I'm working on a counter proposal to that, but it's pretty.
Okay. Counter on injuries?
Right, and what I'm thinking is that the intent is the same, there were just a couple of language changes. There were a couple of what we perceive to be new items. They may not be, they may, it may not have been intended. So when we do our counter proposal, we'll address those issues then. But
Yeah, that's fine. Some of the contract language, as you know, is kind of difficult to interpret, the current contract.
Yes.
And so injury leave was an area especially where I couldn't tell if they were really trying to depart from civil service or not.
So I'll give you one good example that I had a really tough time getting my head around was the holdbacks. The way that particular
Callbacks?
holdovers, excuse me. Holdovers, the way it was written in the old contract, it was very hard to understand exactly what it meant. But I think we've talking to with regard to both sides and the practices that I think we were able to pin that down.
Okay. Very good. Okay,
But
so
what I was gonna say is on the other, there's 3 other TAs that we're looking at, was TA 14, TA 21, and TA 30. Although we have agreed to most of the provisions in those proposed tentative agreements, there are still a couple of issues within those that we're working on. And if we can agree, we'll agree, but if not, we'll propose counter proposals on
okay,
those.
very good.
Okay. And we're also working on, we've received your counter proposal for disciplinary appeals. We're working on that. We're working on impasse, and I believe we just received your grievance counter proposal, which we're also looking at this morning, in addition to other issues that those are not the only ones we're looking at. I just wanted to let you know we received those.
Yeah, and I sent you 2 more counters on Article 23.
Promotions.
Promotional procedures, and 32 deputy and assistant chiefs.
Okay.
I sent those with the grievance procedure, or maybe I sent those.
You sent them with the grievance procedure, I
Right.
believe.
Okay. So, in my understanding, Roxy, I'd been planning to start looking at like this holiday sick vacation leave personally, but my understanding was you were working on something on that and
Yes.
you wanted me to hold up.
Yeah, I'm gonna try and get you because most of that I believe should be the same. It should be agreeable. I don't think that there is any real changes to that.
Staggering issues. Okay. Always good to hear.
So I did have one question on Article 32, the deputy chief and assistant chiefs, with regard to you added a section 3 appointment of 3 deputy and assistant chiefs. What you're proposing there is a total of 3 appointments amongst deputy and assistant chiefs, correct? Not 3 of each.
That's right. 3 total, but you can do it however you want. You could make all 3 of them deputies, or 2 deputies and 1 assistant, or 1 deputy, 2 assistants, or 3 assistants.
Isn't that less
Obviously,
than what we have
No,
no. Right now you only have 1 appointed deputy and 1 appointed assistant.
actually
But
2
we-
appointed assistants, I thought.
Okay. Well, you have the right to appoint 2.
Oh, okay, I see, that's right.
now? So there could be
Under the contract, we
unlimited-
have the 2.
So unlimited assistant chiefs if they go through a promotional process?
If you have positions in excess of those that you appoint, they have to go through a promotional process. That's right.
So it's not an
And
outright
some of your-
prohibition on the total number you have in your organization, it's
Oh,
just
no.
those that are appointed by the chiefs?
By the chief, yeah. In fact, you've got several non-appointed assistant chiefs right now, is my
Yes.
understanding.
Mhm.
So yeah, it's a total of 3, but you mix and match however you want.
Okay. And it's the same as, it gives us the same number of appointed positions we had in the old contract. It just doesn't designate the actual rank.
Right.
Okay.
Yeah.
Okay, we'll look at that. And then I see that you, because of the additions and the counter proposals you made with regard to Article 32, deputy chief and assistant chiefs, you incorporated parts of those changes into the promotions article as well.
Yeah, that's, with the exception of that last section of the promotions article, the changes that I made, I think, are really not substantive at all. I added deputies because it's foreseeable that you could have competitively tested deputies.
It just makes it clearer.
Yeah,
Okay.
that's right.
Yeah, well, because right now,
We're talking about
well, it
Article
relates,
23.
yeah, it relates to that because right now, under the Civil Service Act, you can appoint, the chief can appoint the deputy chiefs. I'll look at that, so, but if there is a deputy chief position that comes up that is competitive, then it does clarify that this is what their promotional eligibility requirements are.
Yeah, you know, I changed the language just a little bit to clarify that obviously these appointments come from within the Corpus Fire Department. You know, the way it was written, I mean, you know, somebody said, well, could the bat chief from San Antonio be eligible? And I said, I don't think so, because it refers to, but I changed the language a little bit to clarify that.
Just to clarify.
I can't imagine a circumstance in which the chief would want to bring somebody in from outside at that high level. I mean, at the chief or assistant chief, maybe it makes sense, but not.
Okay.
I mean, the department head or assistant department head, but not below that.
Okay, let me see if I had any, while we're here. Yeah, we're going through the grievance procedure as well.
Okay.
Most
Okay.
of that is, we're gonna work on, I know the big issue on the grievance procedure is that first part, the scope and exceptions to the grievance procedure, et cetera. And we're gonna work on that.
Okay.
I
Yeah.
see your point. I don't wanna create, my intention was not to create traps and et cetera, or, you know, or any ambiguities, and, so we'll work on making that more clear and.
Yeah, I've, you know, and I've made it, I mean, I think I've given you plenty of bargaining history that the grievance procedure is limited to alleged violations of the contract. We can't grieve, you know, things that aren't covered by the contract. And, but I just see all that's, and so your first laundry list of what has to be in the grievance, I think all of that is pretty much in there.
Okay.
And required by the current form that they're using as well.
That's right.
But the second laundry list just seems to me to be a
The
collection of
exceptions.
gotchas.
Okay.
I mean, some of the exceptions I've given you, like discipline, things that aren't covered by the agreement, you know.
Okay.
Okay.
We'll look at that. I think, you know, we'll work really hard to come to terms on, you know, be able
Okay.
to negotiate and come
Yeah,
to terms on that.
you know, I see that we have a good, with those three that you're considering TAing on, and the impasse, discipline, and a grievance procedure. I mean, we seem to be really close on those. So
Okay.
maybe those are where we can focus today.
Oh, one of the other things I needed to ask while we're here, just on the promotions article, while we're going through it, I did notice that you had, we had put in that reopener clause just to, because we didn't want to waive in any way or limit our right to establish by ordinance, have the city council establish by ordinance the classifications and numbers, et cetera, the way we usually do. So I was wondering what the reasoning for the deletion of that was.
You know,
Because it's kind of understood anyway, I'm guessing.
not exactly. I mean, if you look at the current contract, and I don't have it with me. Oh, yes, I do. I mean, the current contract kind of, you know, and even your proposals, I mean, you know, there's a whole, I think that the only possible classification or position you could eliminate would be firefighter 2 EMS. And so we understand that the city may be contemplating that. But if that is in fact what you're trying to do, we want to have that discussion now at the table. Let's talk about it. I mean, for example, you've got a whole promotional process
Right.
just for firefighter 2 EMS. The way you qualify for captain is either 2 years as a firefighter 2 EMS or 10 years as a firefighter 1 or something like that.
Not for captain.
For firefighter 2 driver, excuse me. So, you know, there's all those issues, and so if you just suddenly say, okay, well, we decided we're going to abolish firefighter 2 EMS, all those issues come to the fore. But then, what happens if, you know, and you've said in your impasse thing, well, we'll talk about what would be the impact on wages, step salaries, eligibility for promotion, et cetera. But what happens if we can't come to agreement at that time? You know, when we were talking about the EMS thing the other day and we got a little bit off track, I mean, within our own caucus room, we're talking about all kinds of scenarios. But we want to deal with that a little bit more upfront now.
Okay.
So
Now, let me understand, just so I understand what you're talking about when you're saying eliminate the firefighter 2 EMS position.
if you do that, and then where do the job duties of the firefighter 2 EMS go? For example,
You mean just get rid of that and leave firefighter 1s and firefighter 2 engineers and just completely get rid of that one? Is that what you're talking about?
that's what we think you might be thinking about, yeah. Because, you know, right now, when you staff an ambulance, if you have to put a firefighter 1 on there, correct me if I'm wrong, you give that firefighter 1 move up time.
Okay, I see what you're talking, yeah.
You know, so where's that job, if you do away with the firefighter 2 EMS, where's that job duty gonna go?
Okay.
You know, I mean, there's so many thorny questions that kicking the can down the road, well, we'll cross that bridge when we come to it, can lead to another problem. So we reopen and we negotiate, but we can't come to agreement. What do we do?
Right.
Do we go
Okay.
through the impasse procedure as to that one issue? Those are some really thorny
Yeah.
issues, and so we're not.
And that's a discussion that I'm glad that we're having, because, you know, if you're talking about it that way, then we kind of become indirectly limited on how we can, if we wanted to reorganize the department and say do 5 ranks instead of whatever the ranks are right now, just do them separate, you know, we would be required, you know, we have the ability to do that, but of course it affects wages and, you know, the base pay and the steps. It affects the promotional eligibility, because then those kind of become moot. So, you know, and we understand that we cannot unilaterally do those changes, and we would have to negotiate and have an agreement with the union on that. So I'm just concerned. What I want to do is I want to leave that. I want to retain our right to do that, but of course figure out a procedure that if something like that were to ever happen, that there would be a reasonable time, reasonable notice, reasonable time to negotiate before anything like that happens. Because usually when they set the classifications and the numbers, it's through the budget process, and of course that takes a lot of time. So we would probably have to do it almost a year ahead of time. You know, if 6 months, something like that.
Budgets can be amended. I mean, they often
Right.
are. But, you know, I mean, I understand that under the statute, the city council has the right to establish the classifications and the number of positions in each classification. However, the practical implication of the nature of the job is such that every fire department that I'm familiar with, in Texas and out, has the same, you know, kinds of positions. They have the entry, they have the driver, they have the lieutenant or captain who is the commander of a vehicle or a station. They have the bat chief that you know, I mean, you know, so the jobs are kind of dictated by the nature of the beast. It's a quasi-military organization. So although they call them different things, like here they call them Firefighter 1 and Firefighter 2, in San Antonio it's Firefighter 1 and driver, in Austin it's Firefighter and, what do they call it, fire something, engineer or something, you know. So, you know, the practical implication, and generally the way things have evolved is the EMS job has generally been a job that's been pegged at that second level, at the driver level, and that's what y'all have done. You know, although you really have carefully defined it as 2 almost different jobs within the same pay classification, but the way you've worked it out through the years really, you know, big consequences. You know, you can't really hopscotch the one driver to get, you know, to the other unless you spend a heck of a
Right.
long time at firefighter one. So, you know, if that structure is a problem, you know, let's
Okay.
deal with it.
Let me do this then. Let me have conversations on my end with what you've asked right now. Kind of start that conversation on my end. That way we're prepared to have a good discussion and see if there's something that we can discuss with regard to rank structure here.
Yeah, I mean,
Because if it is an issue, and then, you know, and then if we can kind of hammer it out here and get concerns and address those concerns and be able to, without waiving our rights to restructure, if there's issues that we want to hear them so we can address them, and then that way that if we have to renegotiate the promotions, we're not spinning our wheels doing negotiation on something that's going to become moot in the next year or two, and kind of just take care of it here. So let me have those conversations on my end, and then we'll meet it.
and that's really the only issue where I think we're apart.
Okay.
Substantively on the promotions article.
Okay.
But and you know.
And let me pose it as I understand it. You don't have any problem with our retention of the right to establish the classifications and the numbers. The issue becomes how it affects.
Yeah,
How
all the
it-
existing rights
all
and
the existing rights.
expectations of firefighters. You know, if somebody has, and I'm not pulling out any actual example, but let's say somebody, firefighter one, and they've never tested for firefighter two EMS. And they said, I'm gonna wait my 10 years or whatever it is, and then I'm gonna try and go straight to driver. Well, they put in 8 of those 10 years, and, you know, then if we change the rules of the road on them, how does it affect that person? Or, you know, if you eliminate the firefighter 2 EMS, a bunch of people put in a lot of time studying to get to that position, and if you just do away with it, and other people get to now bypass that, you know, I mean, there's so many little thorny issues
Okay,
in that.
I see.
And, you know, I mean, I don't get any sense that the people on my side of the table are adverse to talking about all of that, you know, to find some kind of happy middle. But it's better to address those issues now openly,
Okay.
rather than, you know, just kind of kick the can down the road.
Sure. Okay, let me have those discussions on my side and let you know when and where we can discuss that here in the next couple of negotiation sessions.
Okay.
So, okay, well that answers my question on the why you deleted the reopener. So what I'm gonna ask is that we caucus again and kind of go, I'm gonna go work some more to try and get you some more TAs and counter proposals, and then I guess we'll, what time is it right now? Is that clock right? Is it almost noon?
Yes. It is
We'll
almost
touch
noon.
base about 2 o'clock, 2:30.
Okay,
Touch base
sounds
and see
good.
where we're at.
And in the meantime, if there's some,
I'll email them to you before,
yeah, but I mean, if there's some proposal you want us to be working on, we're willing to do that too. I'm not seeing anything really that I would work on other than something like leave, and I'm thinking we're gonna get, you know, something from you on that, so.
Okay, well, what I'm gonna probably do is just work on issues, and as we kind of get them done, I'm gonna try and work on the easiest ones first so that y'all can start working on those.
Okay.
Okay.
Very good, thank
So
you.
we'll do that. Okay, thanks. Oh,
Okay, so we're on Article 15. We've exchanged proposals about that. You said you had a question?
Yes, we received your association proposal today at 2 p.m. and we countered with one here at 4 p.m.
Mm-hmm.
We have accepted all the changes, but the only part, well, there's actually 2 things I need to talk about. Under Section 1, on that last paragraph of Section 1 that states the current practice of adding holidays to vacation time shall be retained. That's it. That's from the old contract. you added this part for each holiday hours will be placed in the firefighter's vacation leave account. And then you outline number 1 for operations firefighters, which are shift firefighters, 12 hours for each day of vacation.
Mm-hmm.
Number 2 for non-operation firefighters, I'm guessing that should probably be specified in a 40-hour schedule, or a
Yeah, it could go on a 5/8.
5/8 would get 8 hours.
Mhm.
And then pursuant to that section found under Article 4 Working Conditions, Section 2D, on the old contract, which states employees who work a weekly schedule of 4 10-hour shifts will accrue and use on an annual basis 3 10-hour personal leave days as provided by the particular, and 7 10-hour holidays. That's where that third
Yeah,
comes from,
when we
right?
go to the personal days thing, we'll have to capture the rest of that.
Okay.
Okay. In other words, you had said earlier that this
That's
portion
right.
of your Article 21 we were going to put someplace else, and I figured these were the some places else.
Yeah, and that's what we're looking at. It just kind of caught me off guard when I was trying to reconcile all this at the, just because the 410 goes to a 10-hour holiday and the regular, I guess, 5/8 get 8-hour holidays.
Mhm.
But I think that's the way it works currently. Is that right?
That's the current practice.
Okay. And then, this last sentence on the old contract, it says if the employee does not work a weekly schedule of 4 10-hour shifts for an entire year, the personal leave and holiday hours accrued for that year shall be prorated accordingly. I'm not quite sure what.
I think what that means is, let's say that I worked the first 6 months on a 4 10-hour schedule, and I worked the last 6 months on a 5 8-hour schedule. Then the holidays that fall in the first 6 months, I'd get 10 hours credit for. The holidays that fall in the last 6 months, I'd get 8 hours credit
Okay.
for. So just, yeah, we
So
switch.
outlining it like this way would should
Yeah.
take care of that.
Whenever the holiday occurs,
It
if
would be
I'm
under-
if I'm a 5/8, I get 8 hours. If I'm a 4/10, I get 10
Okay.
hours.
Okay, if I'm just need confirmation for my team, I think that's the way it works, but I just need confirmation that we could probably
got you.
TA that particular part. On section B, I was just going over the formulas which are on page 61 and 62 of the old contract, and on section B, I think it just may have been an oversight, because it looked like the formulas that were included were not for the holiday overtime pay, but the formulas used for overtime pay for training and prevention and 40-hour employees, and in parentheses callback. So I wanted to look just to make sure that I use the right formulas. That instead of hourly rate, I use dock rate because that's what was used on section A above on your proposal.
So your question is,
Section A seems to be correct. It seems to.
and that's based on that page 61.
On page 61. Section B, which is found on number 1 on page 62, was missing a couple of things. The formulas included were actually the ones from number 2 on 60, on page 62.
Yeah, on page 62, computing.
To compute holiday overtime pay is the ones that we should be using, right?
Right. And didn't I?
On the second, where I made the changes,
Um,
and you had hourly rate, but you had referred to it as dock rate right above that for the regular rate, so I just wanted it to be consistent on A and B.
Okay, yeah,
That's why I did
and
that.
dock rate I think is what they're more
Yeah.
familiar with anyway. Yeah, I'll double check it, but yeah, this is where it came from.
Yeah, and that's what I just reflected what shows on page 62 for the holiday overtime pay, and I just wanted you to look at that to make sure that was correct as well.
I will. I'm looking at it now, and it looks to me like it is. So. Okay, and then I'll double check that, but I'm pretty sure that's right. I don't have trouble with changing hourly to dock. That's the way it's referred to in the old contract, and I'm sure that's what
Yeah.
people are familiar with.
And then you use that same dock rate on section A of your
Right.
section 2A of your proposal
Yeah.
also, so that way it's just consistent.
And then in that last sentence, when applicable, obviously all you mean there is like
If
only
somebody-
one person gets EMS assistant director pay.
That's right.
Well, yeah.
And you only
that-
get you only get certification pay
Yeah.
if you get certification pay. We
Yeah.
don't include any but that's what I mean.
And I thought I captured that. I don't mind adding when applicable, but I thought I captured that when I said to include any longevity pay, sir, blah, 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 received by the firefighter.
Oh, okay.
That's what I meant.
Okay.
I mean, do you think we need that when applicable? I don't
I'll look
mind
at-
adding it, but that's what I mean is if the firefighter gets educational incentive pay, it's added. Obviously, if they don't, it's not.
I would probably be more comfortable with leaving when applicable in there.
I'll leave it in. We both agree it doesn't really change. It just means they get the ad pays that they're currently drawing.
Yes, yeah.
Yeah, I'll leave it in.
Like just because it says certification pay in here and they don't get, some sort of certification pay doesn't mean that it gets included in here.
Right,
It's
no.
based on what they actually get.
It's based on what they
Yeah.
actually get.
So our intent here on the holiday and the holiday pay was to capture and maintain the status quo on the recognized holidays and holiday hours that they do get and the holiday pay. I think that we've included everything that has been that's scattered throughout the contract that reflects that. I'll ask that you prepare a TA on that with the caveat that I need to confirm with my management that those vacation hours that go into the leave accounts are correct. And that's
Okay.
what the current practice is.
I'll prepare a TA, and it's noted that you
I
reserve the
anticipate-
right to have that further review. And I agree with you that the intent was to capture the status quo.
That's right.
So,
Okay, good. Well, I'm glad
It means if I get another vacation day, I'll do. So I'm gonna go petition.
yeah, absolutely. Work for those firefighters.
That's right.
Okay.
Okay.
That takes us to Article 24, I guess is the next one, grievance procedure.
Yes. Yeah, let's see. There's only a couple of issues left here.
Yeah.
On the purpose and the scope and the exclusions, we accepted your changes and we did away with the laundry list of exclusions. That doesn't necessarily mean that they don't apply. It's just I think it's captured by the general exclusions that are listed here. I added number 2, and I don't know that it's Number 2, I added an exclusion. It said any section of this agreement that is specifically excluded from this grievance procedure. I know on number 1 we outlined discharges, disciplinary suspensions, demotions, etc. But for instance, in our management rights proposal, that we retain our management rights, there's a limited. There's a limited. I remember there was a limited provision in there that said that exercise of retained management rights that are not otherwise modified by the agreement wouldn't be subject to the grievance procedure. Of course, if it was something that had to do with a violation of law, you'd be able to file a lawsuit. But it was I know we still haven't worked through that one yet. But if there's anything in the agreement that says, hey, like for instance, I know all these disciplinary appeals have to follow this procedure. It's not subject to the grievance procedure. And that was basically what I wanted to capture. I don't know. That's up for discussion. I'm willing to consider any other suggestions.
I don't think I have any heartburn about this. So when you say any section of this agreement that's specifically excluded from this grievance procedure, you're talking about something that is a reserved management right. potentially.
Yes, or any other provision that comes up, I don't know, just,
I have seen grievance articles that specifically said, okay, you can't appeal alleged violations of this, or you can grieve it, but you can't arbitrate. I've seen that kind of stuff.
so, yeah.
So if you had something like that,
If it's in the contract, it's expressly stated in that particular provision or article, that's what I mean.
the problem that you're going to have, and I don't have a lot of heartburn about, when I looked at this, I wasn't thinking about your management rights stuff, and so I need to talk to my team about it.
Sure.
I don't have a lot of heartburn about it. I just want to be, we would never, well, I won't say never. I mean, people do things all the time that surprise me. If we file a grievance, we're going to cite a specific
Right.
article of the contract, and you're going to say, well, that's not really covered by that article of the contract. That's covered by management rights, and we don't have to accept grievances about management rights. Well, the case law is that if if it's even arguably covered, that goes to the arbitrator for decision. What I'm trying to avoid is a situation where you say, well, that's really a retained management right. We don't agree that that's covered by this other article, so we're not going to agree to arbitrate that. And then we've got to go to court and file suit to require you to arbitrate, and then we win that suit, and now we get to arbitrate the grievance, and it becomes a two-step process, and it becomes very cumbersome.
Mm-hmm.
Now, and I've had to do that. I've had to file that. In fact, we just finished a case in Orange, Texas, where they refused to arbitrate a grievance and the court ordered them to. We've had that in, I think it's Beaumont where that happened recently. And so I'm really trying to avoid that.
Okay.
You're always going to argue, no, that's not covered by that. That's in retained management rights. And my question is, who decides that issue? When you say, well, it's covered by management rights, and we say, no, it's covered by Article 21, work schedules, then is the city going to refuse to go to arbitration and make us go through two steps just to get the grievance heard?
I wouldn't think so, but you and I aren't going to be here, this could potentially be in here for the next 30 years.
It could be.
So
And
that is, we do have to think about that.
Think about that, because
So-
the alternative under FERPA, there's a specific section that says that contracts are enforceable, and so when you say, well, that's not a grievance, because we think it's covered by management rights, I always then have a sort of a two ways I can go. I can say, no, I'm going to file suit to force you to arbitrate, or presumably I can turn around and say, okay, well then I'm going to enforce it under 174.109, I think it is, and I'll just sue you. And I think we both agree that we would rather these things go to arbitration, where you get a decision in a couple, 3 months, as opposed to court, where the average court time after all appeals is a couple of years plus.
2 years if you're lucky. A couple
If
of years.
you're lucky, if they're all feeling like we really want to get something done today. I've seen cases languish in just one court for 2 years. So, that's my only concern about that language is, because almost, this list of grievances you gave me the other day, the arguments are, we think it's covered by this, no, this is management rights. And that argument always exists, and I don't want y'all just to willy-nilly deny a bunch of grievances. And if putting this language in the contract would encourage you to do that, I'd like you to be upfront with me about that, because that would give me pause.
That's not what the intention is. I just wanted, to make sure that this grievance procedure says that it could be any provision in the contract, that wasn't in conflict with when a provision says this is not subject to the grievance procedure, or and we've talked about the list of grievances and when we raised the management rights, and it usually was in defense to a prevailing right / maintenance of standards kind of argument, or which is what is alleged to be a past practice kind of deal, and whether it is or not, and whether we can change it by through our management rights, et cetera. So those kind of went hand in hand. What the intention, when I was thinking about this, I just didn't want this grievance procedure to create an ambiguity where in the other parts of the contract it says this is not subject to the grievance procedure. It'll be through either, a lawsuit or something else. I just didn't want it to be in conflict and create the ambiguity, because if the grievance procedure says here, a grievance is defined as any dispute, claim, or complaint concerning the interpretation, application, or alleged violation of any provisions of this agreement. That's the second sentence on section 1A scope. That could be understood to be in conflict with, say, I know it's not listed here, but the disciplinary appeal procedure, which says this is not subject to the grievance procedure, but yet this sentence says that any provision of the agreement can be.
No, exactly.
So that was the basis and the reasoning for me even putting, and that's why it's kind of very simple in general, because that's just what I was thinking. We've dealt with ambiguities and conflicts and agreements, and they're not fun, and this is the time to get them ironed out, and that's basically what I was thinking about. The one that stuck out that I could remember was just the management rights proposal, because we have that in our proposal, but we have the disciplinary appeals, and I haven't looked through the other proposals to identify where it says this is not subject to the grievance procedure, because there's another way to get this resolved.
Yeah. Okay.
So that was my basis and my line of thinking.
And then if we're going down to initiation of grievances, you've eliminated that phrase in the case of firefighter grievances. I mean, what if the association files a grievance? Who is the grievant?
Usually, it would be whoever the association representative is. It's usually, when they've done it, it's usually Carlos Torres, the association president, files it, or the chairperson of the grievance committee.
When you say the grievance name and title, if it's an association representative, they just have to.
Yeah, and that's why I didn't want there to be just a blank, that we believe this is a class action grievance and it's filed by the association, yet there's no grievance name, or just it would be but from Carlos Torres or whoever the chairperson is, like we've done before, so that there's a representative and somebody has that is actually filing that grievance on behalf of the association.
Okay.
I just didn't want it to exclude it,
Yeah,
because it
I'm
says,
looking down at number 6, the firefighters or association representative's signature. I mean, if it's an association grievance, say you're violating the association's rights as an association, you've stopped allowing the president time off or something like that.
Yeah, then the grievant would be the association and whoever's filing on
Okay,
their behalf.
so in that case, we would just put the grievant is the Corpus Christi Firefighters Association.
Right, that would be who the grievant is.
And their title is Grand Poobah.
Yeah.
Okay.
So that's just what I meant by that. I just didn't want that first part to almost act as an exclusion, that it was an association, they didn't have to provide that information.
Okay. And then item number 4, you made a change. I thought at one point you had wanted us to attach a memorandum of understanding that we alleged was violated.
Yeah, well, in addition, because the grievance procedure is for to interpret, apply any alleged contractual violation. And then along with that, if there's any memorandums of understanding or other documents that are purport to interpret the section that we're talking about, that's what I was asking for. But
Right.
because the memorandum of understanding should not create a contractual obligation, a collective bargaining contractual obligation.
It can in this sense, and in the sense that they've been used in the past. These MOUs normally arise in the context of the settlement of agreements. In the settlement agreements, we've agreed that for the remainder of the term of this agreement, we'll understand Article 21, Section 2 to mean blah.
Right, but it's an interpretation of a specific section.
Right, so you just cite the section, and then you'll hopefully get the MOU either through discovery or when we exchange
Right,
existing.
and so I figured that the discovery process that had already been in the old contract, in which we kind of fixed up a little bit so that the due process is proper,
Okay.
that we would probably get it anyway. Otherwise, you wouldn't be able to use it in the actual hearing.
And then,
So we went ahead and did that.
is there any significance to you, the adjustment versus resolution?
Yeah, I think, and I did that change also on the first paragraph. I just
saw.
think it's, adjustment is confusing, and if it means resolution, people are just more familiar with the word resolution, and this is the resolve, this is how we remedy it. So
Okay.
it was just kind of an easier term to put in there.
Okay. And then, in that paragraph B at the top of page 2, you're saying that if we fail to designate something as class grievance, you might want to challenge the failure to make it a class
Right,
grievance.
not only the designation, but if there's something that would affect a class, but the association has decided to file it on one person, we dispute that and we can't come to terms on that, that would be an issue that we could put before the arbitrator.
Okay.
It kind of, it's either board designation or non-designation, just as the union has the ability to designate and not designate it as well.
Okay. And we referred to the grievance forms there, and you crossed out the D1, et cetera, but all you're saying there is we don't know what it'll end up being.
Right, whatever it's
But
gonna.
Are y'all okay with the current grievance forms? You're not suggesting any change? I looked at them and they seem to require all this information that's in this list of 7.
Yeah, I'll look through them, but I'm very familiar with the grievance forms, and there wasn't really any issues that I recall. I'll look through them, and we'll, if there's anything that needs to be changed, or clarified, I'll present those as well. But the reason I just did the blanks was just we don't know what they're going to be.
Okay.
We agree to the forms. It makes it a lot more consistent and easier to know this is what the package is going to look like. This is what it's, that way we know if something's missing and what we need to get done.
Okay, and the coin flip thing in section 5A seems to be the next.
Oh, before that, we're trying to get the procedures to mirror each other.
Mhm.
There on that, the parties are unable to do so after 14 days. That mirrors the disciplinary appeals proposal, which y'all had agreed to. That one had 5.
Yeah, that's fine. I think that I probably selected 5 here instead of 14. You're always wanting grievances to go relatively quickly, but I don't have any heartburn about 14.
Well, the 14 days is actually if we want to mutually agree on a neutral arbitrator. And when we're trying to find a private arbitrator, it's kind of hard. You have to do research and track them down, see if they're still arbitrating, that kind of deal. And that's kind of hard to do within 5 days. So that was the reason. If we both call each other and say, hey, let's just do the list, that doesn't mean that we have to wait 14 days to do it.
Yeah. Okay. And then the coin flip, I don't have trouble with that, but normally, a lot of times, either TSAFF rep or me, somebody who may not be here in Corpus won't be able to be at the director's office. But if we're willing to trust you, that's not a problem.
That's what we raised. That's why we even put that, because it originally said that that's on the disciplinary appeals. I said, so it said one party would flip it, but we wouldn't be there, so we chose to just choose who the neutral is usually the administrator, which is the HR director, or the designee. She has a designee that does all this stuff. So that was why. We'll take suggestions on that. Just to make it fair.
And then 4, you just apparently changed.
It says the same thing. I just used the same language that we proposed in disciplinary appeals.
Okay.
Just so it mirrors.
Okay.
But it basically says the same thing. The parties are responsible for any cost necessary to secure the presence of their witnesses at the hearing, except that the fire department will make subpoenaed firefighters who are scheduled to work available to testify.
Okay.
And that's the current practice as I understand it.
Okie doke, and that looks like that's it. So I need to talk to my team, but I think this one's either ready to TA or close.
Pretty close, okay.
So, okay. So let's go to 25, which is
That's a disciplinary appeals, right?
one second. Okay, in that section 2A, what I understand you're saying is that the fire chief can suspend, demote, or dismiss, and those decisions are subject to appeal through the disciplinary appeal procedure.
Right.
The fire chief also has the authority to issue lesser discipline that will not be, you're talking about like reprimands?
Yeah, I'm talking about oral, written reprimands, what are they called? Performance improvement plans, letters of counseling, you know, things like that that are not really considered disciplinary actions under the Civil Service Act, but are considered disciplinary, progressive discipline under the city policies.
How about if we just kind of like laundry listed them, the fire chief also retains his authority to issue oral admonishments,
I
reprimands.
actually thought about that, but y'all don't like my laundry list sometimes, so I was trying to
Yeah.
make it real general.
Okay.
So that it doesn't tie hands if the policy somehow, for some reason, changes citywide. See, that was the other issue. If I say progressive discipline and then something, you know, the law changes or there's some new policy or some new change in employment, you know, employment discipline, and I didn't want to tie the hands of the chief to not be able to follow the policies.
Okay.
So when I say lesser, I didn't know what, you know, that's the term that I kind of figured out would cover reprimands and stuff that's really just kind of goes in the file and it's not really considered a discipline.
Okay. We may try to come up with some kind of alternative word.
Yeah, I invite suggestions.
Okay.
The main reason, the main intent was when I looked at this with fresh eyes and I thought, okay, when somebody's going to be looking at this way down the road, the fire chief's authority could be construed to say this is all that he can do. All he can do is either suspend, demote, or dismiss. And that's not fair to the chief and that's not fair to the firefighters.
That wasn't our intent.
Yeah, and-
I mean, I
and I
think
know
you
that's
could
not
leave
our
that
intent.
last sentence out and we would agree at the table that clearly it doesn't affect, I mean, there is a body of law under the Civil Service Act that says, for example, written reprimands are not discipline.
Right.
And they even go in the firefighters' so-called G file, which is not subject to Public Information Act requests.
Right.
And, you know, so we realize, I've just, in my own mind, stopped thinking of those as discipline at
Okay.
all, but, okay.
So that was my only concern, somebody reading this who doesn't know the law and is not
Yeah.
familiar with that. So.
Okay, and then we're looking at C3 at the bottom of page 1. You know, it's funny because I've dealt with this issue in several cities, and you're the first ones that haven't wanted the reinstatement list to go longer than a year. I'm wondering why.
Well, I didn't actually, I deleted it because I wanted, we hadn't agreed to it, but I wanted some discussion on it because I know the Civil Service Act provides that for a promotional position, the list lasts a year.
Right.
And then for an entry, I believe it's 3 years, whatever, if I recall, I haven't read it in a while.
I don't remember about the,
It's-
but,
There's
you
something
know,
about 3 years, I think, for an entry level, if it goes all the way down, and then when they get to the bottom, the last person, I guess, kind of at the entry level position doesn't have a place and they get discharged, then that
Right.
particular list is valid for 3 years.
for example, if a captain gets fired and you promote a captain and you promote a firefighter 2, and then the captain gets reinstated, then the last hired captain gets demoted involuntarily, really without right of appeal, but put on a reinstatement list. Now, under the Civil Service Act, those reinstatement lists only last for a year. But that really isn't very fair to the firefighter who promoted and then through no fault of their own got demoted. And so the idea is to have a permanent reinstatement list that you'll use. You're never going to have more than 1 or 2 names on a reinstatement list. And you'll just pick off that reinstatement
Okay.
list before you pick off the next promotion list. It just guarantees that a person isn't inadvertently hurt.
Right.
Because there was a person coming back that wasn't expected to come
Now,
back.
currently, we're under the Civil Service Act
Mhm.
on this issue.
Right.
Currently. So
Right.
currently, what we deal with, what we have is we do have that year list, and we do have the 3-year for the entry level list. So I just wanted to talk a little bit more about it because it seems if for some reason that list is infinitely valid, and for some reason we never get out of some economic hole that we get in, that we would have that list, which would probably go away at some point because
Well, yeah, remember we're only talking really about promotional lists here.
right.
Because, you're almost always down a couple of positions at the entry level just because you wait until you get enough to make a class to fill that group. And with promotional lists, I think that our interests really coincide here. We're just trying to prevent somebody from being inadvertently hurt. They promoted legitimately based on their test score and their relative rank, and then they get demoted, and people that were on lists after them, kind of pass them up. When
Even though they were already up in that position, right?
Right, and I didn't take the next promotional exam because I was already promoted. So now I'm going to have to wait another year, and all these people that didn't study when I studied and didn't get promoted when I got promoted kind of advance beyond me. So just make sure that that person isn't hurt. And I think that both the city and the association have an interest in avoiding that happening. This whole scenario, of course, we hope won't play out.
That's right. We hope we never
Hopefully,
have to use this at all.
You'll make
Right.
provisional spots, but if there's a economic downturn or something and you can't do that and you have to demote, then just give those people the next, bite at the apple.
Okay. With that information, I just wanted to see a discussion on it, and I meant to put it in a comment, and I forgot. I had
Okay.
been doing that, just putting my question. Let me talk to, on this particular issue, let me talk to my team about it, and we can determine what we need to do with that. Because,
Okay.
you're right, I'm thinking about it, and even though we're in this, that list is valid for a year, sometimes it takes more than and it may happen in the middle of a fiscal year. It's probably going to take more than a fiscal year to correct whatever economic downturns are happening. So, that's one thing that we are taking into consideration as well.
But even in an economic downturn situation, when you have a promotional vacancy, the act requires you to fill it within 60 or 90 days. So if you have a person who's on
Oh,
a
someone who
captain reinstatement
retires,
list,
right.
and anybody retires or resigns, that vacancy has to be filled within
I see.
90 or 60 days, depending on whether a list
And
is
you want that
currently
person to have first bite of the apple. Okay.
Yeah, so it's even in an economic downturn, you're probably not going to go more than a year without having to fill a promotional vacancy, except in the very upper echelons. Bat chiefs obviously don't happen near as often as drivers.
Okay.
Okay, the next one I've got is section 3B, and that's on page 2, and you've crossed out the right to a union rep at an investigatory interview, and I'm just wondering what your thinking is there.
Which one is that? B?
3B as in boy, it's on page 2.
Oh, the only part I actually meant to cross out was the being able to review the investigatory file in advance. We have no objection to them having an association representative present at the interview.
Okay.
So that was my mistake. I went.
So you just want to cross out the review the investigatory file in advance?
Yeah.
Okay.
That's
Okay.
the only thing, and you can note that, and I'll correct it.
Okay.
But no, we
Well, you don't have to correct it. I'll make a counter.
We have
and
no
I'll-
problem with the association representative being present at the interview, but because it was all, I guess I just did that all at once.
And is y'all's current policy, practice that you don't let them review the file before?
I believe so.
Okay.
I believe so. And
If-
that's the way,
if-
what policy has been for a long time.
If you could maybe confirm that for
Sure.
me, that will,
I will.
because that'll help me know if there's any real. Okay, now we're down to section 4. On the initiating appeal part, I'm trying to understand if you send the certified letter, I guess what you're saying is you're giving them 3 extra days to file their appeal, but to show that service was made, are you requiring a green card to come back, or just the fact that you mailed it
Well,
constitutes service?
the problem, this is what I was trying to address, because it said that it would be 10 days from the receipt of a certified mail through an alternative service.
Mm-hmm.
As you know, when we have to resort, in litigation especially, when we have to resort to alternative service through certified mail return receipt requested, a lot of the times you get the receipt back and they didn't pick it up. And so that could be leave it open-ended forever. Their right to appeal if they never pick it up, and then they somehow walk in and someone serves them. It could be 5 years later, they still have 10 days to appeal. That's what I was trying to get around. If you look up at the alternative service, it says that proof of such service is sufficient to move forward on the disciplinary action or to uphold a disciplinary action. So what I was trying to incorporate was kind of that mailbox rule that we use. It's a 3 day. It's assuming that it takes about 3 days to deliver a piece of mail. So that's why we did the 13 days. That was my thinking, because we may
So whether
get
or
the
not
green
they
card
pick it
back.
up.
Right. Then we may get the green card back that they did pick it up. Then we may get it back that they didn't pick it up. So whether or not they picked it up, the right to appeal would be that 13 days.
Okay, I got
And
you.
if they're under investigation, they should already most likely be on notice at this point, because we have to follow all these procedures that this is going to happen.
Okay.
So
Okay.
that was the issue I was trying to fix.
And then selection of arbitrator, I'm looking at the bottom page 3, you just human resource director or designee.
Yeah, I just added designee. I think we had included designee in our last proposal, and it was it may have been left out inadvertently, but
On the initiating appeal, just above that,
Mhm.
the 4B, it says you file a written appeal with the Director of Human Resources. All you really mean by that is with the office
with
of
the
the
office,
director.
right? The office of the director.
Okay,
You don't have to actually hand deliver it to the.
okay, okay,
And that's the way it's always been like that,
okay.
where we just file it with the office.
This is something that just came up. I'm looking at section F on page 4.
Mm-hmm. Is it F5 that you're looking at?
F1 actually.
Oh, sorry.
It's agreed language, I know, but I want to, that last sentence of F1 says, except for true rebuttal witnesses whose testimony could not reasonably have been anticipated, the arbitrator may exclude the testimony of a witness that a party failed after timely request to identify. Just by luck of the draw, we've had this news the last couple of days, the guy in Charleston, the video of
The guy
the
who
police
videotaped
officer.
Yeah.
And the thing about that is, in listening to those news stories, what it turned out was there was an individual that videotaped the altercation between the officer and the victim, and was not known to anybody at the time. And then they gave that tape to the victim's family. And I just want to, if it's a situation like that where you truly don't know a witness is out there, that they exist, you find an eyewitness to some incident who, through no fault of your own, you didn't know about at the time you identified your witnesses. In that sense, would you agree with me that the arbitrator could allow that person to testify if satisfied that it truly...
I think if you could establish good cause, because that would go to both parties.
Yeah,
It could
yeah.
happen to anybody.
Yeah.
And we've come. I know I've had that issue pop up before, many times. And if we're able to establish good cause and prove that we weren't hiding that witness or anything like that, then usually.
And that's the...
And I agree.
Yeah,
I agree.
and that's the sense of that word "may" there. That in a normal circumstance, I would expect the arbitrator would exclude the witness. But if it's a situation like that where there is good cause,
Right.
they can still
That
allow
may,
them to testify.
Yeah, and that's why it says may and not shall.
Yeah. Okay.
So that may would allow for good cause
Okay.
arguments.
Okay. I just want to make. And so I've got the changes to the others till we get down to number 5.
Yeah, I was looking through number 5, and I guess I may have overlooked it. The new stuff in the red, or the I don't know what color it shows up on you, but it says as appropriate to the nature of the case, subject to the rules of discovery in Texas civil cases. That's what the current practice is within this disciplinary procedure from the old contract. So
I had struck that discovery text because,
okay.
And the reason that I had was because, most of the association representatives, I can't remember if we're talking about grievances or discipline.
This should be, you know what, let me see.
I think this is discipline, right? Yeah.
This is discipline.
They're not lawyers, and so they don't really know the rules of discovery in Texas civil cases. I think that an arbitrator certainly could be guided by that, but what union reps are generally aware of is so-called requests for information needed in aid of arbitration, and there is a kind of a body of case law among arbitrators about when and what kinds of discovery are appropriate, and so I didn't want this to we're arguing back and forth with the arbitrator about whether it's appropriate. It seems like a non-attorney is disadvantaged if an attorney is, throwing out arguments based on the rules of discovery, which you and I know, even among attorneys, it can be pretty arcane at times.
That's usually the toughest part of the fight.
Yeah, so maybe we consider dropping that.
Okay. I couldn't
In both
remember,
instances.
right, and I couldn't remember why it wasn't in there going through, because we've gone back and forth on this
Right.
proposal. Okay, well, we'll I'll talk to my team about that.
Okay. And then arbitrator's authority, you've got this sentence in yellow?
Yeah, on arbitrator's authority, I think, okay, I have 2 sentences highlighted in yellow. That first sentence, I believe, is from the old contract. Unless otherwise stated in this agreement, the provisions of the agreement control over conflicting provisions of the Civil Service Act, Civil Service Commission rules, and AAA rules. And then the last sentence is new, and it just it's confusing to me. Sometimes I'm one track. It says the Civil Service Act and Civil Service rules promulgated thereunder control over conflicting AAA rules. So
I thought, my recollection is that came from y'all's proposal originally.
Did
and I
it?
just agreed to it. I think it did.
because it was
I don't
it was
remember if
outlined
you
as-
put it in
I'll look. It was outlined
grievance,
as
arbitration, or
new.
discipline.
To me, I think the arbitrator's going to look 90% to the agreement to understand what
Absolutely.
are the,
It was
if there are
identified as
Civil
new
Service
lang-
Commission rules that also pertain, that those could be relevant. but-
Right. It was identified as new language, and I didn't recall or see it in my prior grievance proposal. So I'll look at that. I just wanted.
It was either there or in the discipline. And so I think at one point I was trying to get them consistent also.
Okay.
To me, that last sentence, I think it makes sense that the provisions, I think we both agree that this agreement controls over conflicting Civil
Over
Service
everything.
Act and Civil Service Commission
Right.
rules. But the whole thing about AAA rules, we don't, if you want to get rid of all that from there on, I'm fine with it. Okay, because it
Okay,
doesn't
let me
add
look.
anything.
Yeah, the AAA rules. Sometimes it throws a wrench into things. I've had that problem.
Yeah.
Have you ever had an issue with where even if you don't use AAA, but your contract says that you'll do an arbitration under AAA rules, that AAA kind of wants to come and step in or charge?
I haven't had
They find
that happen yet, but I don't think we need to involve AAA other than getting a list from them.
That's right.
And they charge you a lesser fee for that. And that's probably to our advantage, because most of these arbitrators we see in list after list, and we can contact them ourselves after we get the list from AAA.
That's right, as long as we contact them through, you know, everyone's, on the same, you know, on the same communication. You
I
know,
mean-
I'm kind of thinking.
It came from the old contract.
It did. I'm kind of thinking about, because normally, most of these arbitrations, whether it be disciplinary or grievance arbitrations, are pretty informal. And they're run pretty much by the arbitrator themselves.
Yeah.
So I wouldn't be opposed to just getting rid of saying that we're gonna be running this under the AAA rules unless you see any benefit to that.
I don't. If you look at that item number 8 at the very top of page 5
Mhm.
of your proposal, it says unless otherwise the conduct be governed by AAA rules. I think we could get rid of that. And because, you know, basically what should govern the arbitrator in a disciplinary case should be the agreement and then any civil service rules that the agreement doesn't conflict
That's
with.
right.
And that ought to cover
Everything else is pretty much, we, like with discovery, we give it to their discretion and they have case law that they have to follow.
Yeah.
Yeah, I'm gonna look at that as well, but we may be able to, because I've had some issue where AAA rules actually, you know, make things a lot more difficult.
Yeah, I'm going to write you a counter on this, and because we just got really a couple of little things.
Yeah.
And
And the only thing on H with arbitration expenses, it says that we'd share the fees and expenses with the arbitration. I put AAA and arbitrator because I didn't want us to share equally in the fees of any attorneys that may be hired, and, you know, representatives, any representatives, any experts, anything like that. What we're really talking about is either the AAA charges an administration fee for getting us the list and hooking us up with the arbitrator, and then the arbitrator expenses. So
I
that's
agree
why
with
I did that, just to make it clear. And I invite suggestions that if you have a better idea on that issue.
no, I don't guess we have time today, but I will write a counter on this and get it to you. I mean, I think we're essentially so
We're
close
very,
that
very close.
we've got a virtual TA on both of these.
I believe so as well.
Okay.
Any little issue, I think that we can still, you know, if
Well-
anything that remains, we can probably work out here at the table.
The ball's in my court. I'll get you something before the next meeting on
Okay.
Wednesday on all 3 of these. The TA on 15, and you look at it and see if
Sure.
you got your double check to do.
Yeah, I anticipate that we will be able to confirm that is what happens. I just need to verify it.
Okay. So that's that on those 3.
I still have more coming, and I'll probably try to get them to you well before Wednesday, especially because we're going to be working back to back, so that we actually have some stuff to be working on for both of us.
Okay.
So
Okay. Well, I'll work on these 3. Just what I've got review is you were looking at possible TAs on 14, which is supplemental benefits, 21 work schedules, and 30 miscellaneous.
yeah, those are some of the things that I still need more information on from my end.
Okay. And where are you on that impasse procedure?
That's the first one I'm trying to get to you before Wednesday.
Okay. And
I just said I saw a lot of progress in the ones we were moving today, and I figured let's just try and get those done because we were
Yeah.
so close.
yeah. Okay. Okay. Very good. Is there anything else we can do
No.
today, or?
No, I don't have anything else right now. I wish I'm almost done with the impasse, but I'll get that to you. That'll probably be the first one I'll get to you.
Okay. Very good.
So.
Okay. Thank you.
Very good. Okay, we made a lot of progress. Okay.
We did.
Thank you.